Hi friends, hope you are doing well. As we all know, पोस्ट कोविड जब से CIT अपील में फेसलेस रीजन की इंट्रोड्यूस हुई है तब से आज तक बहुत ही बड़ा बैकलॉग है इनकम टैक्स के पास अपील डिस्पोज करने का। बहुत सारी पुरानी अपील जो कि असेसमेंट 2015-16 से लेके 2020 तक पेंडिंग है अभी भी इन टूडेज डेट फॉर द डिस्पोजल एंड हियरिंग। और ऑन अदर हैंड इनकम टैक्स डिपार्टमेंट is going on adjusting refunds against those pendency of demand. So इसी मुद्दे को लेके एक रिट पिटिशन फाइल हुई थी बिफोर द ऑनरेबल गुजरात हाई कोर्ट, और गुजरात हाई कोर्ट ने CBDT को इनकम टैक्स डिपार्टमेंट को फटकार लगाते हुए ये डिसीजन दिया है कि आप अपील आपकी कैपेसिटी नहीं है अपील डिस्पोज करने की, तो दूसरे हैंड आप रिफंड भी एडजस्ट नहीं कर सकते, यू आर नॉट अलाउड टू डू सो। सो इस डिसीजन को हम आज इस वीडियो में डिस्कस करते हैं। लेट्स गेट स्टार्टेड। ये जजमेंट डिलीवर हुआ है ओम विजन इंफ्रास्ट्रक्चर प्राइवेट लिमिटेड वर्सेस इनकम टैक्स ऑफिसर बिफोर द ऑनरेबल गुजरात हाई कोर्ट। Heard the learned advocate for the respective petitioners and learned senior standing counsel for the learned advocate for the respective respondent। यहाँ पिटिशन एसएससी ने फाइल की है और रिस्पोंडेंट है इनकम टैक्स डिपार्टमेंट ITO। So all the matters, this is the crux of the matter, all the matters are pending before this court on the ground that the Commissioner of Appeal are not disposing the pending appeals on one hand, and recovery proceedings are initiated by the respondent income tax department for the outstanding demand. This court passed the following order on 17/9/2024। क्या ऑर्डर पास किया था? इंटरिम ऑर्डर। Learned Senior Counsel submitted that the appeal filed by the petition before the CIT appeal is pending for more than 4 years and same is not being heard. It was further submitted that though the petitioner is protected by this court by permitting the petitioner to operate the bank account as per order dated so and so, till this date no further progress has been made with regard to hearing of the appeal by CIT appeal। अब बहुत सारे केस में जो बहुत हाई पिच डिमांड होती है तो टैक्स पेयर इज नॉट एबल टू डिपॉजिट 20% ऑफ डिमांड फॉर ग्रांटिंग ऑफ द स्टे। तो बहुत सारे केस में डिपार्टमेंट जो बैंक अकाउंट है उनका अटैच कर लेती है। तो यहाँ कोर्ट ने इंटरिम ऑर्डर लिया था कि बैंक अकाउंट आप ऑपरेट कर सकते हैं, बट उसको भी 4 ईयर्स यहाँ हो गए हैं, 20 का ऑर्डर है। लर्नेड सीनियर काउंसिल further submitted that there are more than 5 lakh appeals pending across the country to be heard by the CIT appeal in faceless regime. On the other hand, Learned Senior Standard Counsel submitted upon instruction from the CIT and FAC that the efforts are being made by the respondent department to hear the appeals expeditiously. However, it is not disputed by the Learned Senior Standing Counsel that in the month of February 24, more than 3 lakhs appeal were pending. Be that as it may, we take a serious note of the pendency of the appeal before CIT appeal for more than 3 years. It would be in the interest of all to join the following respondents to resolve the issues pendency of appeal which has clogged the system. So इन सब जो authorities है CBDT को, फाइनेंस सेक्रेटरी को, उनको हाई कोर्ट ने यहाँ रिजोल्व करने की अपील की थी। The respondents are requested to file the response affidavit on the following. First, High Court ने clarity मांगी थी pendency of the appeal before the CIT appeal. Second, average life of the appeal, जो appeal हम file करते हैं Form 35 और disposal of appeal, उसमें time gap total average कितना होता है. How many appeals are allocated to each commissioner of appeal on average basis. If there is an inordinate delay such as notice in the instance case, what are the remedial measures that may be suggested by the CBDT. Issue notice to the newly added respondents returnable on 1st October 24. Direct service through email is permitted. Thereafter, on 1st October 24, the following order was passed again. Learned Senior Standing Counsel has tendered the affidavit in reply on behalf of the respondent number 325 in response to order dated 17/9/2024. The same is ordered to be taken on record. On perusal of the appeal in reply filed, it reveals that total appeals pending before the appellate authority as on 26/9/24 are as under. यहाँ आप देख सकते हैं फेसलेस CIT के पास ऑल ओवर इंडिया पेंडिंग अपील है 3,90,878। नॉन फेसलेस है, जो सर्च के सर्वे के केसेस होते हैं उस केस में 80,170, और जो ज्वाइंट सीआईटी है अभी 10 लाख से जिसका जहाँ कम एडिशन है वो अपील पेंडिंग है 1,09,140। सो ऑल ओवर 5,80,188 अपील्स एज ऑन डेट pending है. However, it is not stated in the affidavit with regard to the allocation of the above appeals between 279 CIT appeals who are working in faceless manner and 64 CIT who are working as in a non-faceless manner, and 100 JCIT who are allocated to the appeals where appeals of disputed demand is less than 10 lakh and the appeals arising out of the order passed under section 154 by the CPC. In the affidavit, no data is given with regard to average life of pending appeal as such. Such data is stated to be not readily available with the NFAC. With regard to the issue of the allotment of the appeal, on average basis, it is stated as under with reference to the total appeals allocated to each commissioner of appeals. On an average basis, it is humbly submitted the total number of CIT and non-faceless are 279 and 64 respectively, and total number of appeal pending is 4,71,000. The average pendency with faceless CIT is around 1400 cases, यानी एक CIT के पास एवरेज 1400 केसेस है एंड नॉन फेसलेस केस पर 1252 अपील्स पेंडिंग है. Now, with regard to the remedial measures suggested by the CBDT for reduction of the backlog of the pending appeal, it is stated that the CBDT has issued guidelines for the priority out of the turn disposal and 100 JCIT as appointed in the year 2023 as per the section 345MA of the IT Act. E-dispute resolution scheme is notified under Finance Act and new measures have been introduced by Vivad Se Vishwas scheme in Finance Act 2024, and CIT Commissioner Office have been empowered to set aside the ex parte assessment orders. Except the above remedial measures, no other measures are stated in the affidavit with regard to as to how the pending appeals with the CIT, which is around 1400 cases per faceless, shall be heard within what time span such appeal shall be disposed by the CIT appeal. यानी और कोई मेजर नहीं है इनके अलावा जो CBDT के पास है फॉर द डिस्पोजल ऑफ 1400 केस है एवरेज CIT अपील के पास, वो कैसे डिस्पोज करेंगे, बहुत साल से पेंडिंग है. No measures are mentioned with regard to the bunching of similar appeals or repeated issues for the different succeeding years in appeals covered matters which would speedily dispose such appeals by the CIT appeal. Be it as may, in facts of the case by order, the petitioner is already protected by restraining the respondent from taking any coercive action. In view of the above observation, let there be a fresh additional affidavit in reply to be filed by the respondent before the next date of hearing as placing on order data with regard to average life of appeal as well as remedial measures for the backlog of the 5,80,000 appeal pending as on 26 September 24. Now, pursuant to the aforesaid both the orders, respondent number 325 have tendered the affidavits in reply. On perusal of the affidavits filed on both the occasion, it appears that respondent to 325, instead of addressing the issue of pendency of the appeal before CIT appeal, has tried to justify the proceedings undertaken by the CIT appeal for the disposal. Now, यहाँ जो हाई कोर्ट है वो CBDT को क्या कर रही है? We are at the pain to note that in spite of the giving specific directions in paragraph number 9 of the order 1st October 24, the respondents have ignored the same and repeated what is stated in the earlier affidavit, with addition only reference to annual central action plan and Vivad Se Vishwas scheme for the issuance of the pending of the more than 5,80,000 appeal before CIT appeal. So यहाँ ratio let down हुआ है. Be it that as it may, if the respondents are not interested in resolution of the issue of pendency of appeal, the manner in which it ought to have been resolved by the classifying appeals as per the issues concerning the recurring issues, covered issues, we are of the opinion that no recovery should be made from the SSC during the pendency of appeals. Therefore, in all these petitions, there shall be no recovery of any outstanding dues from the petitioners whose appeals are pending during the pendency of these petitions. So that was the order of the High Court. Now no recovery can be made, especially जो SSC गुजरात जुरिडिक्शन में फॉल होते हैं उनको ये जो ऑर्डर है हाई कोर्ट का उससे बहुत ही फ़ायदा मिलने वाला है, और दूसरे जो जुरिडिक्शन है उनको भी राहत होने वाली है कि ना कोई रिकवरी नहीं हो सकती, बिकॉज CBDT itself is not taking any actions or measures to dispose this 5,80,000 appeals on one hand, and getting one recover money and from the taxpayer. आई होप ये वीडियो आपको पसंद आई होगी। इसके रिगार्डिंग कोई क्वेश्चन है यू कैन पुट इन कमेंट बॉक्स, आई विल ट्राई टू आंसर ऑल योर क्वेश्चंस एंड क्वेरीज। थैंक्स फॉर वॉचिंग दिस वीडियो, हैव अ गुड डे।